Welcome to Criminal Law Unfiltered.
Welcome back to Criminal Law Unfiltered with my man, Robert M. Helfend. Robert is the founder of Helfend Law Group and a criminal defense attorney who focuses on serious state and federal cases. With more than 4 decades of experience, he has worked with individuals at every stage of a criminal matter, including those who know they are being investigated but haven't been formally charged. In many cases, that period of uncertainty can be just as critical as anything that happens later. I'm Evan Mack, and today we're focusing on what it means to be under investigation before charges are filed and how that stage can shape what comes next. Robert, my man, welcome.
Good morning. Glad to be here.
Good to see you, Robert. So this is interesting stuff, though. How does someone typically find out they're under investigation if no charges have been filed yet?
First of all, if it's a federal case, you usually get a target letter. The U.S. attorney will send you a letter saying, hey, you're a target of a grand jury investigation. Here's the number for the federal public defender. Why don't you reach out to them? And it's normally served on them by an FBI agent, or not an FBI agent, any kind of a federal agent. It could be Homeland Security, it could be any kind of federal agent. And so once you get that letter, that's when a smart person, if you have money, will call an attorney, because that target letter, if you're not familiar with them, gives you all the information you need. Because what that target letter is basically telling you is giving you a hint. Hey, we are watching you, we are investigating you, and we're about to indict you. So why don't you get a lawyer or call the federal public defender so that they can contact me and we can start off, and I will send your lawyer or the federal public defender, I'll send them the discovery. Then you could see what we have against you. And then we could all talk as adults about what could happen if you want me or want us to indict you. Then you can figure out what's my best course of action. Do I want to figure out a plea agreement ahead of time, or do I want to let them indict me and go through all of that? If it's a state case, you're under investigation. Number one, the one thing that could happen is you get arrested, and a detective is assigned to the case. They will talk to you right then and there, and then if you're fortunate enough to have money and you can bail out, you bail out, and then you can either wait for your court date, the public defender will talk to you about it, or you could hire counsel then. And somebody like me, I would call the detective, talk to them, let them know don't talk to my client again. Don't call him or her, don't call her. And so that I know when it will go to the district attorney's office, and then call them and let them know I'm representing this person. And an interesting thing about that is a lot of times I'll talk to a detective, and they've told me through all my 43 years now that sometimes in a state case, when you get arrested or you're contacted, or the other way to know in a state case whether you're being investigated is you get called by a detective, and they want to quote unquote get your side of the story. And so I end up calling them so that they know, don't contact my client again, contact me. And don't call them to say, oh, we got your phone, we're going to give it back, because that's another way. Oh yeah, come on in, we'll give you your phone back. Oh, by the way, let me ask a couple more questions. You don't ever want to answer any more questions. But what I've been told by countless detectives is, you may not, as an attorney, you may not get through to the detective you might not get through to the district attorney that's thinking of filing this case, or the city attorney on a misdemeanor. But believe me, when you leave the message there, they know now that your client has representation, and it makes a difference. It makes a difference to the district attorney or the city attorney to know that the person that they are investigating and gathering information on has counsel. So it makes a difference. That's all I'm saying.
So, how can actions taken during an investigation influence whether charges are eventually filed?
Well, it depends on a lot of factors. I mean, I'll be quite honest with you. Sometimes it doesn't. Sometimes it doesn't affect it. It definitely will affect it. And I mean, that opens up a lot of doors to different answers. But sometimes it affects it only in the way that, like federally, then you're dealing with the U.S. attorney directly. They send, like I have something right now, they just sent me the discovery. I'm about to send the discovery to my client, and then we will talk about the next steps. Do you want to settle the case? Do we agree that they have the goods on you or they don't? Do we just want to tell them, no, we're not going to settle? And then I call the U.S. attorney and go, look, politely, I just tell them, we don't want to settle right now. Let's just go ahead and, you can do your indictment. But let me know when you do the indictment so we could voluntarily surrender instead of you going out and arresting him. So that helps. Who wants to be arrested in the middle of the morning and your neighbors are going, hey, what's going on with Johnny or Mary? So that's one of the benefits to having counsel. The other thing is, an estate case, you could do the same thing too. You can contact the district attorney or the city attorney and arrange to know when is it. I've done this many times. Okay, you're filing it. I'm going to self-surrender my client to court. Don't come and arrest him. The other thing is that you want to prevent your client from being interviewed. And that's very crucial, to not let your client be interviewed by law enforcement. That you don't want to give them your story. First of all, obviously, you don't want to let your client confess to anything, but it's more than confessions. It's It's more than a confession. You don't want your client to admit they were there even, because that's part of the defense is could be, I don't know, but sometimes in cases, part of the defense could be, I was not the right guy. So if you say, I don't even know this person, then the identification of your client is still up in the air. So it could go a lot of different ways that we could talk about how a lawyer can affect a case in the beginning. It can go many different ways depending on who's investigating you and when you contact the lawyer.
What risks come with assuming that no charges have been filed yet, for a person?
There is no risk. Um, it, there's no risk in it. I mean, you just don't want to deal with law enforcement or any type of law enforcement person on your own unless you have experience dealing with them. I mean, I have experience dealing with these people, and I have had experience representing myself in a case. I'm only talking about a traffic ticket, and I was going to fight the case, and oh, this was a speed trap, and yada, yada, yada. And when I went to court to fight for myself, it was a long, long time ago. And I realized I'm not good at representing myself because since it's me, I'm too emotional about it because it's me. And I don't want to be emotional. And so you a person that represents themselves has a fool for a client. That's just an old axiom that you learn in law school. You should never represent yourself. And you just don't want to say the wrong thing because you think it's going to be an innocent answer to a question by law enforcement. And then great, we now know that you know this victim. You admitted you knew the victim. That's half of the battle. So we know you were there. Anyway, you don't want to do that. And you also don't want to give up devices. You don't want to give up your phones. You don't want to give up your computers unless they have a warrant. So there's a lot that goes on that a lawyer can help you with, but law enforcement knowing that you have representation goes a long way.
So how do things like, search warrants, subpoenas, or contact from certain investigators, fit into this stage?
Well, if you have a subpoena, that's a problem. You may or may not be able to quash it. Normally, you get a subpoena in federal court. Um, that's one way the U.S. Attorney's Office will get your attention is they will have an agent serve you with a subpoena to testify before the grand jury. And that's how you know you're either a target or a subject of an investigation. And so when you get that from the client, it'll have the name of the U.S. attorney that's in charge, or you'll know who the agent is who served it on them, and you can call them and get the name of the U.S. attorney so then you contact that U.S. attorney and you work it out. You talk to that U.S. attorney and let them know, hey, I'm not letting my client testify in front of the grand jury. I mean, so if you want to put them up there and have them take the fifth, that's fine, but that's what's going to happen. We're not going to say anything. So subpoenas, though, I've had subpoenas in state court. Normally, those are rare. Sometimes they subpoena your bank records ahead of time. And I've had people say, what can we do about that? There's really not much you can do to combat that. The bank's going to have to, unless there's some privacy issue, there normally is a privacy issue. And you need to, there's nothing you can really do about that. But what you can do in that kind of a state case is you can get a copy of the subpoena or contact the legal department of the bank or of Snapchat or whoever it might be so that you can find out who served this subpoena on these records. Then you'll get the name and the phone number, and then you can contact them, and so you could discuss the next steps. So it's always a good thing. I mean, this is always subject to somebody having the money to do that, to do the right thing, and to be able to have legal counsel at an early stage.
So, in all your experience and all the things that you've seen, can you share an example of a situation where what happened during the investigation stage, it affected the outcome later on?
In a sex case, at least around here, I'm sure it's like this all around the country, but before the Los Angeles County DA's office will file a case, I'm sure it's true in Ventura too. But before they'll file a sex case, they need corroborating evidence. Not enough that a victim says, this is what happened to me. They want corroboration. And so they try to get it in many different ways. They'll do a pretext call to you and get you on the phone with the victim on the phone, trying to get you to acknowledge something that happened. An apology over the phone, an acknowledgement that it happened. Sometimes I'll have the victim or the victim's mother contact you and try to see if you would write an apology letter. Things like that. And so when I've gotten cases ahead of time, I've been able to tell the client, listen, they're going to call you. You're going to get a call from um, Miss Jane Doe um, sometime. And I want you to know when that call comes, you need to know that it's being recorded. And when they ask you if you will apologize, or if they ask you, I want to talk about what you did to me, you need to understand that is a pretext call. You're being recorded, and that is going to be used against you in a trial. So you best say, I don't know what you're talking about, and hang up. So, I mean, I have to think about the times. I mean, there's other times where that's helped, and then they didn't file the case because, I didn't allow them. But you need to understand there's a long statute of limitations on a sex case. So you can never, ever, ever, ever talk about it. Don't text somebody back. Don't email them back. Don't, and don't talk about it over the phone. Don't take the call. It's done for the rest of your life. Don't talk about it.
So to kind of wrap things up there, Robert, what do people tend to misunderstand about being under investigation before charges are even filed?
What people don't understand is that when this is a first time for people, they don't kind of understand that these people are the people that are investigating you are not your friends. And there's a misunderstanding that you think by being nice, or let's sit down at the boardroom table and let's talk this out as friends, okay? And it'll just go away. That's the problem, is you need to understand these people are not your friends. Even though they're acting like they're your friends, they're not your friends. And they're just trying to get you to admit something. They're trying to get information from you that's helpful to their investigation. And different police agencies or different detectives have different techniques in doing that. But most of them try to be friendly. Okay? When they're friendly, hey, somebody so and so told us that this is what happened between you. Hey, I'm just here because, I just want to hear your side of the story because, you're not going to get another chance to do this. So why don't you just tell us your side of the story so we know where you're coming from? And they say it in such a nice way. Okay, you're thinking, oh, okay, yeah, I'll tell you my side of the story because if you hear my side of the story, it makes a lot of sense. Okay, I wasn't there, or this is what really happened. She consented, he consented, he, and you'll not file it. And so that's the big mistake that you make because you think you're going to talk them out of it. It's already once a victim, at least in state court, makes an allegation, that police agency is obligated to follow up on it, and then they're obligated to turn it over to the district attorney or the city attorney. And they're, as the lawyers for the state, the lawyers for the county, the lawyers for the government, the DA's office, the lawyers for the city attorney, they're the ones who now have the task of deciding whether to file the case or not. It's not the detective who decides whether or not to file something. It's the prosecuting agency. So that is the key here. And it makes sense when you've never dealt with law enforcement, you don't know, and they come at you so friendly, and you just think you're going to talk them out of it. Don't fall for it.
That's good stuff. Mr. Robert, appreciate you, sir.
Thanks for having me.
That's it for today's episode of Criminal Law Unfiltered. Being under investigation without charges can feel uncertain, but the decisions made during that time often carry long-term consequences. To learn more about Robert Helfend and the work he does at Helfend Law Group, visit robertmhelfend.com. Thanks for listening. Don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. And we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.